Well, good morning. My name is Tim Stevenson. I'm the Executive Director of the Legacy Foundation here at Shell Point. And for the last two seminars, since probably November, I've been promising you some special news at the January seminar. And I want to introduce to you for the first time Joanna and Lydia Stevenson. I have heard a lot of guessing as to what the announcement might be, and I just want you to know, since I have this platform on which I can do this, I am. And identical twin baby girls born January 6th, 2014. This brings our grandchildren to 4. I'm not going to show you the others. However, those of you who are mathematicians will recognize that there's something exponential going here. We went from 1 to 2 to 4, and we're a little apprehensive about who gets pregnant next. And so I'm going to show you another picture, and I'm going to show you the real one. See, we don't have to share. With the other grandkids, I always heard, well, aren't you going to share? And now I don't have to. And our son Chad and daughter-in-law Lindsay are doing well. I talked to him yesterday. It was 14 below zero with 40 below zero wind chills in South Bend, Indiana, and they are just hunkering down and taking care of babies. So I just wanted to give you that introduction. So that is the news that you've been waiting for all these months. So all that said, thanks for indulging me on that. And you'll notice that there is a pink theme today. I wondered if we'd pick it up with the evaluation forms and the pink sprinkles on the cookies. We'll go back to chocolate chip cookies next time, but you got sugar cookies with pink sprinkles this time and pink napkins.
What's he saying?
Just be happy I didn't give you all pictures and expect you to put it on your refrigerator. For those of you who may not have been a regular part of all of these seminars, from month to month, it's our intention to give you informational seminars on a variety of topics. And at least once a year, we have an attorney or two come in, and we just talk about issues. Maybe it's a change in the tax law with regard to estates. Maybe it's advanced directives. Maybe it's the importance of planning in one area or another. And this month is one of those where we are going to follow the topic, Tales from the Trenches. And the idea of this is that those of us who are involved in helping people plan and settle estate matters see sometimes things done well, sometimes not so well, and we get to see the repercussions of that. Well, that's like any kind of a profession where you get to see it over and over and over. And so some months ago, we were talking together about what our seminar would be for January. We usually plan these 6 to 9 months out. And we were talking about what we would plan to talk about, and we decided that this would be a good time to just tell tales of what we see. You know, the names and the places have been changed to protect the innocent. But to give you a little bit of a feel as to why sometimes you're asked to jump through hoops and do a variety of things. I will appreciate some feedback from our time together, and so we do have this pink evaluation form for you. If you would give us some feedback, talk to us in the ways that we've put here. If you'd like a follow-up call or anything like that, fill this out. Some people return it through the intracampus mail. Some people give it to our staff as they leave. Some people just leave it on the seat. Any of those is fine, but we do pay attention to that, and appreciate that kindness on your behalf. Our guests this morning are Craig Hirsch and Michael Hill. Craig and Mike are part of the Shepherd firm that's been established in Fort Myers for many years. They're good friends of Shell Point and are both board-certified wills, trusts, and estates attorneys. They're good friends. They know Shell Point well. Let's welcome them this morning.
Thank you, Tim, and thank you, Tim and the Legacy Foundation for inviting us again to appear before you. How is everybody today? Good. Glad you're not up north where it's 40 below, right? Are your kids commiserating with you now? Are they calling you and saying, do you have a spare bedroom? Of course. Say yes. Come on down. So like Tim said, we're going to talk a little bit today about planning pitfalls that we've seen. And you know what this speaks to is, we get this all the time. Many of you are clients who are here today. We get this all the time. Why do you guys make things so complicated, right? How many of you feel that we make things too, just lawyers in general, make things too complicated? Don't we? Yeah, well, government too. Almost all the time, we hear, my situation's simple. It's just simple. I've been married twice. We have different sets of kids. We want some to go to his and some to go to hers. It's simple. So everybody thinks their situation's simple. And y'all sometimes believe that we get paid by the word, right? Or by the pound. For those of you who have Mike and I's trust packages, don't you feel like we get paid by the pound with those big binders that we give you? And a lot of people also think, and this is where I'm going to pat myself and Mike on the back a little bit, that all lawyers have the same abilities. We all graduated from law school, didn't we? Right? And what's that? We hope, yeah. Yeah, that'd be a problem, wouldn't it? But there really is a difference. Those of us who are board certified in certain areas and have those credentials, and then sometimes we run into this, and where people believe that this is all just easy stuff. They can just draft it themselves, right? Or go to LegalZoom. And for some people that may work. It really may. But what we're going to show you today is some things, and we're going to ask you some questions, see what y'all think, see what you think about what we show you on the board. And we're going to see how much, and by the way, my experience with this crowd is that you are of the most sophisticated clients that we have. Most of you know a lot about this stuff. And we expect you to be on your sharpest edge today when we ask you questions. But here's the thing. When we're talking about words that we use in legal documents, it's plain English, right? No. Something, for example, income. The word income. Doesn't the word income mean the same thing to everybody? When you use income, for example, in a legal document, it might mean income as opposed to principal and income. Principal meaning the corpus, the investments themselves, and the income might be interest and dividends. But what about capital gain? Is that income? When something says to distribute out income, does it mean distribute out capital gain as well? How many people say yes, it means distribute out capital gain? How many people say no, it doesn't mean that? How many people do not want to answer and embarrass themselves? Capital gain is actually corpus. It's actually principal. So if I have a distribution in my document that says income to my spouse for life, it usually does not mean capital gain, because the capital gains are intended to be reinvested and produce more income. So what we're trying to say in this slide here is that things that might seem intuitive, or might even seem relevant, or might seem just this simple, this is the way it is, if you don't know what the legal term means, you could get yourself in a world of trouble very quickly. So, with that said, I'm going to turn over to my esteemed colleague, Michael Hill, who's also board certified in wills and trusts, and he's going to talk to you about why you guys just can't have those one-page durable powers of attorney.
Thank you, Craig. He actually let you guys off the hook a little bit with the income definition. I thought he was going to go into gross income versus net income, distributable net income, distributable investment income, all these different words that also mean income, but he didn't go there. So where we're going to go now is with the powers of attorney. And we've talked about powers of attorney before at this workshop or at these workshops. Very, very critical document to allow somebody to sign your name for you when you are unable to. Okay, that's when the power of attorney really hits home. If I am in the pavilion or in King's Crown and am not physically able to get to the bank or make my own decisions or sign my name, I name my attorney-in-fact, who is not us, by the way. Okay, your attorney-in-fact is your agent, your daughter, your son, your person, to legally sign your name. Right? So that's what the use of the power of attorney is. So the question is, how simple can this document be? Can I just have a one-page power of attorney that says, Sally can do anything that I can do. Sally can sign my name for me if I'm there. And for years, I've railed against the simple power of attorney because it needs to go farther in my opinion. The banks always before have said, no, we want some specific powers. We want you to be able to specifically write checks and specifically handle investments, specifically sell the real estate, and those types of things. But before, back the old law before the 2011 change, that authority, that one-page power of attorney would actually work in most instances. Again, I didn't like them because what happens if a banker or some bank attorney said no? But so I've talked about the one-page power of attorney for a long time, but never actually had an actual example of it showing up in my conference room. Last month, I got it. This was like finding the Holy Grail. You know, I was very, very happy, not happy when I saw it, but I was like, this is the example that I've been using forever. I so-and-so appoint so-and-so my attorney-in-fact for me and my name, et cetera, et cetera. Basically, it says you can do, and then it goes on to say, all acts done by my attorney-in-fact conferred during any period shall have the same effect as if I would have done it, right? So again, it's that very, very simple one-page power of attorney. I name Sally, she can do anything I can do, and then I sign my name, and we're done. Anybody see a problem with this? Is everybody comfortable with this type of one-page power of attorney?
What happens if Sally dies?
That's a good question. What happens if Sally dies? We'll talk about that in just a minute. The witnesses are down here, so I kind of redacted this version. Here's the problem. Under the new power of attorney statute, the one that was just enacted in October 2011, this is what I call a general grant of authority. Sally can do anything I can do as if I were there. Just general, not anything specific. The problem is, under the new power of attorney statute, this language is no longer sufficient to grant any authority. Said another way, she can't do anything with this paper. She can use it as a coaster or whatever else you do with spare paper, but she cannot go to a bank and use this type of power of attorney any longer. Under the new power of attorney statute, the agent, the attorney-in-fact, has to have specific authority to do what they're trying to do. Again, to write the check, to pay the bill, to sell the real estate, to do anything, to sign your name for you. So, with that in mind, and a lot of you guys have seen this, what we came up with a few years ago is we have this obnoxiously long 35-page power of attorney form that we use now. And it goes on and on and on ad nauseum, and it's a pain. Those of you who've done it, you got to initial a lot of places, and then you got to sign it at the end, and it's like a little paperweight. But this is what is going to grant your agent, your attorney-in-fact, the ability to do what we want them to do ultimately when the time comes. Because remember, what's going to happen is, when is this going to actually be used? Chances are it's not going to be when you're alive and well and capable of your own. If it is, we might have some problems. But it's going to be when you're in the pavilion or when you're not able to do it yourself. And so what's a bank going to do with this language? They're going to say, this doesn't work. Go have mom or dad sign a new one. What's wrong with that? You're not capable. You don't have capacity any longer. So what's the consequence of that? Anybody guess? Court. Guardianship court. We're going to guardianship court. I'm going to have one of my partners drag you in front of a guardianship court, and we'll have the interview, and we'll have the committee convene, and we'll have one of the kids appointed your court-ordered guardian. Okay, just because we've got this the simple, nice, easy power of attorney. Very, very dire consequences when we're relying on this, and so it's very, very important to have a good, solid power of attorney in effect at all times. With someone that you obviously trust implicitly to act in your best interest. So that's the one-page power of attorney. Again, I've railed on it for a long, long time, but I finally have a concrete example. Because usually what I'll see is I'll see a handful of pages, 4 or 5 pages, and it's not about the length of the pages, or the length of the document, but usually I'll see, well, you can do this, and you can do this, and you can do this, and then you can do everything else. A lot of them make a good faith effort to listing a lot of things, but then they just stop and ends up back at this provision. And again, if there's something technical or something a little bit different, a bank might say, whoa, time out, show me the exact language in the document that says you can do it. Fair enough? All right, so that's the power of attorney. Now, back to the issue over here. What's wrong with this? I named my son Henry to serve as my attorney in fact, again, my agent to sign my name. In the event Henry cannot serve, then I name my daughter Henrietta as my attorney in fact.
No last name.
Well, okay, fair enough. No last name. Again, this is just kind of an excerpt, but good point. What's going to happen when Henry goes to use the power of attorney? What might the bank ask? They might ask for original. That's right. What about me? Are they going to ask anything about me? I'm the signer of this. I'm giving Henry the authority to sign. They might ask, where am I? Where's Dad? Where's Mom? Where's the person that signed this? Tell me what's going on. Legally, they're not able to do that under the new power of attorney statute, but a lot of times they're going to ask anyway to make sure that I'm not still around, to make sure that I haven't revoked this, or that I haven't changed it, or that Henry's not trying to take advantage or do some kind of abuse or elder theft or whatever. There's a provision that the statute names it. Some type of embezzlement. That's when Henry goes. Well, what's going to happen when Henrietta goes? They still going to wonder where I am? Probably. Who else are they going to wonder where they are? Henry. That's right. So when Henrietta goes to use it, not only is she going to have to prove to some banker or some banker's attorney that I'm out of commission, they're also going to have to prove that Henry's out of commission as well. That's just, again, it's just additional red tape, additional hoops that Henrietta, that alternate's going to have to jump through. So what we've been doing for a long time, ever since I've been practicing at least, is Henry has one power of attorney. I name Henry as my attorney in fact. It typically does not name a successor in that document. And Henrietta is going to have a second power of attorney. I name Henrietta as my attorney in fact. And they will not name each other. They will not reference the other in that actual document, because I want Henrietta to be able to use that ultimately when the time comes. So that's kind of our practice. And for some clients who have me, I'm a perfect example. I have 4 kids. Now they're all young, so we don't have powers of attorney yet, but when they're older, I'm going to have one to my wife, and I'm going to have one, hopefully, to each of my kids. So that's 5 for me. And then Jamie's going to have 5 for her. So it's kind of obnoxious, again, to have 10 35-page documents, but I want to make sure that they can step in and do whatever they need to ultimately when that time comes. I never want to have to run into guardianship court. Correct. Good point. What happens if they don't agree, or how do they know, or what do we do? Generally, we'll have instructions with you. We will, the custodian, as the attorney, who has the actual original power of attorney, as to when we release it to Henry and Henrietta. So generally speaking, we've got an escrow letter where you tell me, release it to Henrietta only if Henry's out of commission. And I'm kind of the gatekeeper. We're kind of the gatekeeper.
You may want to talk about springing powers here, too.
Oh, yeah, springing powers. It's another, and it's not really raised here. A springing power of attorney. What about this provision? I I give Henry the authority to act, but only when I'm incapacitated. That's what we call a springing power of attorney. It's not effective immediately. It's sprung at some later event when some event has happened. And again, the normal provision that we see, or that we see try to be implemented, is my incapacity. Well, practically, there's a problem with that. Who determines my incapacity? Is it a guardianship court? Is it the doctor? Will HIPAA prevent the doctor from giving the opinion? All those normal kind of issues. But even above that now, and again, back to the 2011 Act, springing powers of attorney are done. No more spring can be sprung in the powers of attorney. They all have to be effective immediately. So if you have a provision in there, you might want to take a look at that and see what needs to be changed with that. So power of attorney, very, very important to make sure that we've got it and they can actually use it when that time comes. All right, switching gears. Unintended consequences. Simple example. We got an IRA beneficiary designation. And most of you, this is not a problem, but we see it on a pretty regular basis. I know Tim sees it and Craig sees it all the time, where I've got my beneficiary designation, and one of two things has happened. Either I have failed to name a beneficiary, I just never filled the form out, or I've actually seen clients do this, where they write my estate, make it payable to my estate. So when I die, my IRA is payable to my estate. Anybody have any guesses as to what's wrong with that? Taxes? That's kind of the big one. My estate, my will, is typically going to do the right thing, and it's going to funnel it to my wife or to my kids. It usually will eventually end up in the right place. But under the federal tax law, back to the income tax rules, the IRS is going to tax all of the IRA immediately. It's all going to be immediately due, taxable income, no ability to stretch it out over the lifetime of the beneficiaries, which we typically like to do. You know, if I've got $500,000 IRA or 401k, you know, my beneficiary is looking at $500,000 worth of income taxes, taxable income this year, and that's not good. You know, usually if we've got even a spouse beneficiary, she might be able to, you know, extend it over, you know, 5 or 6 years, even in a bad example. You know, with a spouse, you know, younger than 80, you know, we're going to be able to extend it out much longer than the IRS would allow this provision. It's kind of rare that we see it, but something to be keen on. I see it, frankly, I'll see it not necessarily named the estate as the beneficiary, but what I will see is if we change custodians. If we were with UBS and we switched over to Charles Schwab, just as an example, a lot of times this gets missed, and the beneficiary isn't actually listed, and it's just blank. And then when we're sitting there afterwards, it's like, oh, that's not good that was, you know, that they didn't update that. Always make sure we're diligent on our beneficiary designations, especially on the IRAs, because the income tax consequences of that. Another one. Let's take another one. Here we go. Here's a 401k beneficiary designation. Fidelity, you know, again, no offense to Fidelity or UBS or any of these folks, but I name my accounts. And what about this one? I'm going to name my primary beneficiaries as my grandchildren. How old are my grandkids? And again, let's assume that I named them all by name and put their dates. What do we have? What kind of grandkids do we have? Minors. Any problem with minors and IRAs or anything? Yeah. Yeah, if they're not adults, if they're not 18, there's no problem with a minor inheriting assets. The problem, though, is what happens when they go to use it, when they need to spend it. We've got a guardianship again. We're back to guardianship court. If I don't put some strings, if I don't create a trust, or if I don't do something that names, you know, Johnny as you know, Tommy's trustee or as Tommy's agent, we got some real problems. Okay. Now, again, this is one that I don't see a whole lot where we just list it, you know, directly to my grandchildren, but this is what I see a heck of a lot. Life insurance beneficiary designation. John Doe, he's going to name Anna Doe, who is his daughter, 100% beneficiary. Again, no problem. She gets it. She's an adult, assuming she's not assuming there's not a special needs or some, you know, financial problem or you know, some spendthrift or something. Anna's probably okay, and so I don't have any problem with that. What's this little fine print down here, though? The grandchildren's clause. If an insured's child is the beneficiary and he or she dies before the insured, the child's share will be divided among the child's surviving children, if any. What if her children are grandchildren? What if, God forbid, Anna predeceases mom or dad, or John in this case? Aren't we back to where we were in this, where I've got a minor grandchild? Even though I didn't raise that issue specifically, it's always a possibility if, God forbid, something happens to one of our children. And again, the plan needs to address that and think that through. I mean, that's kind of a logical one. We don't want to chase too many rabbit trails because we could go on forever. Back to what Craig was saying, we build all these things and explore all possibilities. But this is a very real one, and it's just the next in line. So again, some type of provision that says, hey, if we got grandchildren, send it somewhere else. Send it to some protective trust just in case they're a minor. And all that's done in the will or in the trust or in the proper beneficiary designation planning. Fair enough? All right, next.
Okay. What Mike said as well that I want to build on is with those beneficiary designations. The custodians, the companies, UBS, Fidelity, Vanguard, whoever, they will not make a distribution to a minor child because a minor child cannot sign anything that accepts they can't legally sign their names, for example. So that's why a guardianship has to be established when the grandchildren are named directly. So very, very serious things in what appear to be very simple documents. Okay, some problem provisions. Let's put our thinking caps on for these. These are examples that we've really seen in our office that have come through on documents that clients have provided to us. Let's look at this one. I want you all to tell me what we might find as a problem. Father dies with the trust valued at $1.1 million, survived by son John, age 58, and daughter Jennifer, age 56. The trust says, upon my death, that means father's death, my trust shall pay to my son John an income of $24,000 a year in monthly installments of $2,000 and no more. The trust shall pay John this income for the rest of his life. Father described John as a spendthrift, so he wants to keep John from spending all the inheritance all at once. Then it goes on to say, the rest of my estate shall be distributed to my daughter Jennifer outright and free of trust. Okay. Now, anyone, what problems do we see here? Exactly. I'll repeat that. Boy, you guys, I thought I'd have a few minutes of this one to go back and forth, and you nailed it on the very first. Here's how do we know how much to set aside for John? How do we know? Do we set aside $500,000? Do we set aside $300,000? Do we set aside $100,000? Do we just keep paying him the $24,000 a year and wait till he dies and then Jennifer gets? Is that what the intent of this is? She might be gone by then. Yeah. And by the way, oftentimes I get this direction from clients. This is what I want. I want these words. And you pointed out right away what the problem is. We don't know how much to set aside for John. Now let me give you some other problems. Let's clean up that problem. Let's say that we're going to put aside half of it in trust for John for the rest of his life, and the other half goes to Jennifer right away. Okay? What problems might we have with that? John dies tomorrow. Yeah, residue. Let's assume we have a provision about what happens at John's death, but that's a good point. What happens at John's death? What if Jennifer dies first? Right. You guys are going all to what happens next. I'm trying to stay with what's happening now. Those are all good points, though. Well, who manages? We have to name a trustee. That's right. Who's responsible? Who's going to be John's gatekeeper? Is it wise to name Jennifer? Might there be a little acrimony there? Could be. Well, there's actually a tax problem potentially if the trust is large enough. And I've seen this happen from time to time. Income that a trust earns and is distributed outright every year to the beneficiary is taxed at the beneficiary's level. Okay? So if that's all the income John earns this year, $24,000, it's taxed at his marginal income tax rate, which is probably going to be fairly low. Right, gang? Okay. But listen up on this one. Income that's retained in a trust and not distributed gets taxed at the highest marginal income tax rate in 2014 once it's above $12,150. That means it's at 39.6%. Oh, and don't forget Obamacare. That's another 3.8%. 39.6% plus 3.8% is what? 42.4%, right? And if John's unlucky enough or the estate is lucky enough to be in a state that taxes state income tax, we could actually have more income tax. So in larger trusts where we limit the income. Another problem with this is, the $24,000 a year. I've seen some trusts in the 1980s, drafted in the 1980s, that said no more than $15,000 a year income to my spouse. No more than $15,000 a year of income to my daughter or son. What's happened since the 1980s, let's say? Inflation. So when we start to peg numbers like this, it's a danger zone, right? Because $24,000 today isn't going to buy what, $24,000 tomorrow won't buy what $24,000 today buys. Okay, let's look at another one. Many of you don't have residences anymore because you live here, but some of you do. You have residences up north or wherever. Let's look at this one together. Father dies owning a residence that he wants his wife, it's a second marriage, she's age 65, who is not the mother of the children, to live in for the rest of her life, and he's also survived by son age 63 and daughter age 62. The estate and trust assets exceed $1.5 million. Let's look at the provision. This was actually a provision I saw in a document. Upon death, I leave my residence to my spouse in trust. She may live there for the rest of her life. My trust is to pay for the annual taxes, assessments, and such repairs as may be necessary during her stay there. My spouse shall pay for monthly utilities. All the rest and remainder of my estate shall be divided between my son and daughter equally. Okay, now, problems. What do y'all see? Exactly. It's the same problem that we had here. The first problem is that there's no funding for the expenses. How much do we carve out of that $1.5 million to pay for the house for the rest of spouse's life, right? That's a problem. Any other problems we see? Well, let's look at the ages. Second wife is 65, son's 63, daughter's 62. What do we think here? Son and daughter may not outlive wife, right? That's an issue. Now it says everything to son and daughter per stirpes. Do y'all know what per stirpes means? Down the bloodline, right. Some people think it has something to do with a very terrible disease, but it has nothing to do with that at all. It's Latin, right of representation. So, yeah, when we're drafting legal documents and we're trying to put together provisions to benefit different beneficiaries, we have to be conscious of how they interact with one another. These provisions, by the way, weren't right next to each other in the document that I first saw. The provision regarding the residence was in one article, and the provision regarding the kids was in another article, so it wasn't really evident right away what might be wrong unless you saw this all the time, in which case we did, and we saw immediately there's no carve-out. And that becomes an issue. What do you do with that carve-out? How much do you carve out? What if that carve-out's not enough? Who's going to manage the carve-out? So there's all sorts of issues like that. Okay, now for our last wrap-up here, this is something that we've seen quite a few times, and Dr. Stevenson will opine on this when I get there in just a minute. Do-it-yourself amendments. Now, we've had folks who have had very good trusts and wills and so forth drafted up, and they do this. Here's one. naming a trustee succession provision. Now, this is not the actual document. We're just kind of put something up here to protect the innocent. In the event of the person's incapacity, the trust says that Janice T. Spouse is the first trustee, and then Sam J. Friend and Linda T. Gossiper are the next trustees. And then after thinking about it, Linda T. Gossiper was removed. They don't want to remove Linda, so what they did is they crossed through Linda, wrote remove, and then initialed. Did we remove Linda legally? No, why not? Why didn't we remove Linda legally? No witnesses, right? Right? No proper signing of the. And Linda may not know either. So, we've seen this any number of times, and when we sign documents with our clients, we oftentimes warn you not to do this. Don't start scratching through in the margins. Let's look at another one. And I'll have Dr. Stevenson opine on this one. Okay. Specific distribution to Melvin P. Goodfriend was $10,000, but now Melvin's such a good friend that we increase him to $50,000 and we initial it and say, Melvin, you get $50,000. Now, Teresa is a crazy woman. We decided to take out entirely here. She had a $10,000 bequest, but that was thought of differently. Let's take out Teresa. And then to I'm a Be Needy, we increase from $10,000 to $20,000. Are any of these amendments valid? Okay, let me throw a wrinkle at you. Let's say instead of just initialing, let's say that instead of just initialing, the person here instead actually signed it and had two witnesses witness. Is this now a valid amendment to the trust? And notarized it. And notarize is a comment I'll talk to you about in a minute. That's not actually necessary. Notarization goes to the self-proving, and I'll talk about that in a minute. But let me tell you what the legal requirements to sign a will or a trust in the state of Florida are. I must sign in the presence of two witnesses who witnessed my signature and witnessed each other's signature in the presence of each other when we all signed. Okay, that's a general rule. There's a few exceptions to that. So let's assume that you see on this page the signature of the testator, the trust maker, the grantor of the trust, and there's two witness signatures next to it. Is this a valid amendment? How many say yes? How many say no? Yeah, a date. You're getting to the crux of the matter. How do we know that they're all actually in the presence of each other? Right? That's that self-proving clause at the end that you see when it's notarized. That verifies that everybody did what they were supposed to do. But without that, it still might be valid. But the statute also reads, that the signature must be at the end of the document. Define end in something like this. Is this the end of the amendment? Is that the end of the document? What this will breed, something like this, it will breed litigation between these parties. Melvin's going to get a lawyer who's going to say, I'm entitled to the $50,000. Teresa is a crazy woman. She's real dangerous. She's going to say she's still entitled to her 10, and Ima is going to say she's entitled to her 20. And Dr. Stevenson and I worked on a file just like this. How many years ago was it now, Tim?
It's probably been 3.
3 or 4, yeah. And I'm going to let Tim describe to you in wrapping up, and then we'll take questions after, what happened there.
It was fascinating because I was put in a position of the fiduciary to try and settle this estate. And we had one of these kinds of situations where late in life, after the principal had developed incapacity, had lost the ability really to think through these things. A family member came along and decided to disinherit one of the other people in the document and did one of these. And so obviously the one that was disinherited lawyered up. And I remember being deposed downtown Fort Myers, and there were 6 lawyers in the room, plus the transcriptionist, all being paid lawyer wages by the hour as I worked through a pile of documents for several hours. Now, would it have been easier to have had it done right? About six times easier.
Yeah, and there's a statute that says that if a lawyer's work benefits the estate, then the estate pays its fees, his fees or her fees. So when you have 6 lawyers battling this out on an hourly basis, the judge would say they all benefit the estate because they're all working through whether or not this is a valid amendment. You can see how those fees could very quickly deplete what the beneficiaries are going to receive, can't you?
Yeah. It was ugly.
Yeah.
It was ugly. And it reminded me.
And what was the
Don't
result,
do
Dr.
this.
Stevenson, after all those lawyer fees?
It went right back to what they had written from the very beginning, and the one that was disinherited got the full amount.
Yes. Yeah, I'll just kind of wave this around real quick. This book is just the section of the Florida statutes on wills and trusts and estates administration. These rules aren't crazy. They're really there for a reason to protect everyone, so we all play by the same rules when we're doing this exercise. And without these rules, you could see how it could be very anachronistic. It could be anarchy. People could be doing things like this, and you wouldn't know whether it's valid or not. So, we'll just end you by saying that, at the beginning I said, why do we make it so complicated? It's just really it's kind of like Monopoly. Have you all ever read the real rules of Monopoly? It takes a while to read through them, doesn't it? So we're all playing the rules by the same game. It's the same thing here, but the stakes are much larger.
Right. In fact, the matter is, built on that, the settlement of an estate that is done right is actually fairly straightforward.
Yeah.
And I hate to use the word simple because it's not simple.
Right.
But you just follow the rules. And then you come across something like this, it slows it down by a year and a half.
At least.
And it creates tens of thousands of dollars worth of costs on the thought that by doing it ourselves, we simplified it.
Yeah. Well, Mike, do you want to come up? Well, thank you all for coming out today. We appreciate it. We hope that you learned a little something. And we try to make it a little bit more fun today and not so technical on a lot of things. But we're here to answer any questions if any of you have any.
Yes, on inheriting an IRA, if a grandchild, if your son or if your child predeceases the grandchildren, what is the age of the grandchildren? Is it 18 or 21?
The question is, at what age is the grandchildren an issue? Is it an 18? Are they a minor? Are they a minor at 21? That's going to be a matter of state law, ultimately, at the end of the day. At what age in that particular state is the age of majority? For Florida, it's 18. For the IRS, actually, for tax purposes, it's under 21, I believe, still. But that's going to be a state law issue. And I think it's 18 pretty much across the board.
Wouldn't it be simpler to simply have an attorney issue an addendum which would specify the changes?
Yeah, wouldn't it be simpler to have an attorney issue addendum? Exactly. That when someone wants to change the document like what we had before, rather than doing this, we'll just write an addendum, first addendum to trust, and it will be signed with the same formalities that you actually sign the original trust or will.
You didn't use your FRAM oil filter.
Yeah, I forgot. What this is really all about as Tim pointed out, with all the lawyer fees. Do you all remember the Fram? I was going to actually pull, I forgot to do that. Do you remember the Fram oil filter commercial? Do you guys remember that?
I do.
Pay me now or pay me later. Don't you remember the guy said, you change your oil every 3,000 miles or whatever, you know, no engine problems. If you don't do it, you know, then you have to rebuild the cylinders and everything. We forgot to do that. We're actually going to take that off YouTube and put that up here, but
It's a great commercial.
we didn't do it.
But that speaks to that point. You know, it'd be far simpler, far easier, far more clear, or cheaper to just do it right from the beginning. And it's going to cost a few $100 or however, whatever it is, but you're going to save tens of thousands and years off of the distribution. So,
Back there. Yes.
A recent arrival, legitimate resident now in Florida.
Mm-hmm.
All of my legal documents were drawn up about 5 years ago, out of state, by an attorney that also is licensed to practice here. His documents show that he can practice in New England and also here. But he mentioned on the durable power of attorney, October 2011 was changed in the law, and should I be looking at an attorney here full-time?
yeah, the question was out-of-state documents. You know, whether it's 5 years ago, 10 years ago, 15, even last year, for that matter. I did my documents when I was back home, and now I'm a full-time Florida resident. What do I need to do? We have a video. There's several of them outside. It's entitled Florida Residency and Estate Planning. And it's about a 15-minute quick video where Craig and I go through that exact question. So pick this up, and then we'll talk about it. But kind of the short answer is Florida has what we call reciprocity, which means for Florida purposes, we're not going to invalidate that Michigan will or whatever, or New England will, or whatever state it was, as long as there's a few rules. The real question, though, is that actually going to work down here in Florida? Florida's not going to invalidate it, but we got to have a Florida Trust Administration. We've got to go back up to the other state and prove a whole bunch of other things. So is it actually, in the long run, better to rely on that type of document than to simply redo it down here? What I've found is with the power of attorney, with homestead issues, and state death taxes, there's any number of kind of the boilerplate legalese that we put in these type of documents that we need to talk about to make sure that the planning actually works, even though the trust or document might still be technically legally valid. But yeah, absolutely, the 2011 complete overhaul of the power of attorney. I tell all my clients, have a new one. Yeah, it might still be valid, but why take the risk? You know, just do a new one. Same way with the trust. The trust code was redone in 2007. Anybody who's got the old trust code, yeah, it'll probably work, but why risk it? Get it under the new statute. That way we kind of take issues off the table that there can never be any problems.
Yeah, like some of the rules in these books that are different from state to state. For example, which bequests bear the burden of any administrative taxes and expenses? That's all set by state statute. How is the home distributed? Florida is very unique with that for those of you who still have Florida homestead. There are many, many changes and differences between states. And oftentimes lawyers who are practicing up north and are licensed here in Florida but don't actually practice a whole lot with Florida residents, they miss these things. They miss these things.
Yeah. They're major traps for the unwary.
So it's a good idea to have them reviewed.
Yep.
Any other questions?
Yes, sir.
If you're still a non-resident, going back to what we were just talking about, what do you suggest there?
The question is if we're still a non-resident. So we're still a resident back home. We've got a place down here at Shell Point, and we do our summer snowbird thing. Well, my first comment would be, why are we still a resident if we're paying maybe it's not a state estate tax issue, but I'll talk to a lot of state income tax issue, excuse me. from Massachusetts or someplace up north. And it's like, we're spending 6 months here, 6 months there. Did I say Massachusetts? I didn't mean to say that. I meant Massachusetts, of course. So sometimes we have that conversation after this and after talking to the CPA that it does make sense to become a Florida resident. And if that's the case, then we update everything. If you stay an out-of-state resident, then we just make sure that you've got a good power of attorney down here. Maybe we do update the healthcare documents, although Tim's office does a great job with that down here in Shell Point too. So, it's always a good idea. Just double check, especially when we're spending so much time here in the state of Florida.
All right.
A couple more questions?
We'll take one more if there's any, and then we'll stay after. Yes, sir.
Property up in Massachusetts. The Florida resident.
Yes.
And we have trust. It's in a revocable trust.
Yes.
It's worth more than $1 million.
Yes.
And you die and you give it to somebody. You pay it inheritance tax.
Are you asking if you do? Yeah, the question was if we have a fairly valuable piece of property up in one of these other high tax jurisdictions. The question is, and do we pay a state inheritance tax on that? And the question is probably, or the answer is probably.
It depends on the state.
Depends on the
exemption.
state. What I want to caution you against, I had a client from Connecticut run into this problem. In Connecticut, when my client passed away, the credit was, it was $1 million or $2 million, something along those lines. The house was worth about $300,000, $400,000. So they thought, I didn't do the planning. They came to me after the children came to me after they'd passed away. But the client was under the impression that I got a $300,000 house. The credit's $2 million. I don't have to worry about this, right? Wrong. The way Connecticut did it was non-residents only got a pro rata portion of that $2 million credit. And what I mean by that is the estate was actually kind of large. It was $7 million. It was a do-it-yourself, or it was a mess. But it was a $7 million estate, $300,000 piece of property. $300,000 divided by $7 million is a itty-bitty, teeny-weeny credit, a percentage. So when we have multiplied that percentage by the $2 million credit, they actually ended up paying about $50,000 worth of state income taxes on this $300,000 house. All that goes inheritance tax. Yes, did I say property tax?
Inheritance.
Inheritance, estate tax. Different states call them different things. But all that could have gone away with one little word in the trust. Again, back to thinking it through.
Let me add something. Any of you have residences or property in New Jersey? Okay, we don't have that issue here then, but New Jersey has a $675,000 exemption, and who pays the inheritance tax is based on the relationship. So spouses are primary and don't necessarily pay inheritance tax, but if you drop down to kids or grandkids or non-relatives only have something like a $15,000 exemption from their. So every state that has inheritance and estate taxes does play into your plan if you have real property there, even if you're a Florida resident.
Right.
One more back here. And
Okay, we'll take that one, and then we'll stay
What
later.
is the power of attorney? What about the health surrogate power of attorney? Where
Okay.
does that come in?
Yeah, the question was, we talked a lot about the durable power of attorney, sometimes called the financial power of attorney. The question was, what about the healthcare power of attorney? Florida, a lot of states use that phraseology, that nomenclature, a healthcare power of attorney or power of attorney for healthcare, sometimes durable power of attorney for healthcare. Florida has a specific section on the designation of healthcare surrogate. And so we rely on that document, the designation of healthcare surrogate, which is very similar to your medical power of attorney, where you name so-and-so, the ability, a lot of you, frankly, have Tim on sometimes as the healthcare surrogate making your healthcare decisions. And you got to make sure you got HIPAA provisions and all kinds of bells and whistles in that type of document.
Sometimes things change in that too. Sometimes you need the wording that under certain circumstances to give your power of attorney, but not under all circumstances.
Right. Well, typically you'll separate those out. You'll have a medical side and then a financial side. But just as important, the healthcare decisions as well.
Good,
All right.
great guys.
Thank you.
Let's talk about how to make an attorney jubilantly happy. Let me give you an insight to this. You want to make
Be worried.
an attorney incredibly happy. do a do-it-yourself will or trust, but name them to clean up the mess. Okay?
Yeah. I
Thank
have 3
you.
kids but through college.
Yeah.
So, you know.
Because there are a lot more fees to cleaning up the
That's
mess
right.
than there are to doing it right. All that's tongue in cheek. You really want people
No, we
to
want-
do
we
it
want people
right.
to do it right.
You don't want people caught in that mess. We do value the fact that you spend your time with us. We do value your input. If you give us a little feedback, then next month we'll plan to do this all over again. Thanks. Have a great day.
Thank you.